The Supreme Court of India is poised to deliver a landmark judgment. It will address a critical question in the realm of tax law. The court must decide if the transfer of leasehold rights over land attracts the Goods and Services Tax, GST. This issue has been a point of contention between businesses and tax authorities for years. The final decision will have far-reaching consequences. It will impact the real estate sector, industrial development, and the overall cost of doing business in the country. Many companies and legal experts are watching this case with keen interest, as the outcome will bring much-needed clarity to a complex and disputed area of taxation. The matter reached the nation's highest court after the central government challenged a significant ruling from the Gujarat High Court. The lower court had previously sided with the taxpayers. It declared that assigning leasehold rights is not a taxable event under the GST regime. The Supreme Court's bench, comprising Justice Pankaj Mittal and Justice Prasanna B. Varale, will now examine the fundamental legal principles at play. Their task is to determine whether such a transfer should be treated as a transfer of land, which is exempt from GST, or as a supply of service, which is taxable. This distinction is at the heart of the entire legal battle. The specific case that triggered this high-stakes review involves a company named M/S Life Sciences Chemicals. This sole proprietorship firm faced a substantial GST demand. The tax authorities issued an order for over rupees 8.5 lakhs. This demand was related to the transfer of leasehold rights for an industrial plot located in an estate in Ankleshwar, Gujarat. The company contested this demand, arguing that the transaction was not subject to GST. Their challenge set the stage for a judicial review that has now escalated to the apex court, promising a definitive answer that will affect countless similar transactions across India. The Supreme Court's involvement signals the national importance of this issue. The uncertainty surrounding the taxability of leasehold transfers has created a difficult environment for businesses. Companies involved in long-term industrial or commercial leases have been unsure about their tax obligations. This lack of clarity can hinder investment and complicate financial planning for major projects. By agreeing to hear the case, the Supreme Court has acknowledged the need for a uniform and binding interpretation of the law. Its final verdict will resolve the ambiguity and establish a clear precedent for all future dealings involving leasehold rights. At the heart of this legal debate lies the interpretation of key provisions within the GST framework. The Central Goods and Services Tax Act of 2017 defines the term supply very broadly. According to Section 7 of the Act, supply includes sale transfer, barter exchange license, rental lease. Visual diagram supply. Section 7 versus sale of land, Schedule 3. This expansive definition forms the basis of the tax department's argument. They contend the assignment of a leasehold right is a form of transfer or disposal for monetary consideration. Therefore, they believe it falls squarely within the definition of a taxable supply under GST law. However, the GST law also contains specific exclusions. Schedule 3 of the CGST Act lists activities treated neither as supply of goods nor supply of services. A crucial item on this list is the sale of land. This exclusion is the cornerstone of the taxpayer's argument. They assert transferring long-term leasehold rights is equivalent to transferring an interest in immovable property. They argue a long-term lease, often spanning 99 years, effectively transfers most of the benefits and rights associated with land ownership. Therefore, they claim it should be treated like a sale of land and be exempt from GST. The legal question becomes a matter of classification. Is the assignment of a leasehold right a simple service provided by the lessee to the assignee, or is it a transfer of an interest in the land itself? Tax authorities lean towards the former view. They emphasize that in a lease assignment, the absolute title does not change hands. The original landowner or government authority remains the ultimate owner. The assigner is merely transferring their right to use the land for a specific period. From this perspective, the transaction is a service, not a sale of the underlying immovable property. On the other side, Businesses and their legal representatives argue this view is too simplistic. They draw upon principles from other laws, such as the Transfer of Property Act, which recognize leasehold rights as a significant interest in immovable property. They argue when a business invests heavily in a leased plot, building factories, commercial structures, the subsequent transfer of these rights is much more than a simple service. It is the transfer of a valuable asset that derives its worth directly from the land. They believe taxing this transfer goes against the legislative intent to keep land transactions outside the GST net. The Gujarat High Court provided a crucial and widely cited judgment on this matter. In a detailed ruling, the court came down firmly on the side of the taxpayer. It held that the assignment of leasehold rights for a premium or a one-time payment is not a taxable supply of services. Therefore, it concluded that such transactions are not subject to GST. This decision was a significant victory for businesses operating in the state and set an important precedent that influenced legal thinking across the country. The court's reasoning was rooted in a substantive understanding of property rights, rather than a purely technical reading of the tax law. The High Court reasoned that a long-term lease, especially one for a period like 99 years, is a form of alienation of property. It is not merely a rental agreement. The court equated the transfer of such a long-term lease with other forms of property transfer like a sale or a mortgage. It stated that when a lessee transfers their leasehold right to a third party, what is being transferred is an interest in immovable property. This interest is a benefit that arises directly from the land itself. The court found that this was fundamentally different from providing a service in the conventional sense. In its analysis, the court looked beyond the literal words of the GST Act. It considered the nature of the transaction in the context of property law. The judgment emphasized that the scope of supply of services under GST should not be stretched to include the transfer of leasehold rights. Doing so would contradict the clear exclusion of land sales from the tax net. The court essentially viewed the transfer of a long-term lease as a transfer of a bundle of rights so significant that it resembled a sale of the property's economic benefits, even if the absolute title was not transferred. This ruling by the Gujarat High Court became the central pillar for taxpayers challenging GST demands in similar cases. It provided a strong legal basis for arguing that the assignment of leasehold rights is a transaction related to immovable property and should be kept outside the purview of GST. The central government disagreed strongly with this interpretation, which is why it appealed the decision to the Supreme Court. The government feared that this ruling could create a major loophole, allowing many valuable property-related transactions to escape taxation, thereby impacting government revenue. The tax department presents a compelling and structured argument from its perspective. The department's primary contention is that the GST law was designed to be a comprehensive tax on most commercial activities, and the term supply should be interpreted broadly. Officials point directly to the text of Section 7 of the CGST Act, which explicitly includes lease license and transfer in its definition of supply. They argue that the assignment of a lease is undeniably a form of transfer conducted for a consideration. Therefore, on a plain reading of the statute, it should be taxable unless specifically and unambiguously exempted. A key part of the tax authority's position is the distinction between a sale of land and the assignment of a lease. They argue that the exemption in Schedule 3 applies only to the outright sale of land, which involves the permanent transfer of title and ownership. In a leasehold assignment, the original lessor, often a government industrial development corporation, retains ownership of the land. The assignor is only transferring their temporary right to occupy and use the land. Because absolute ownership is not transferred, the transaction cannot be equated with a sale of land and does not qualify for the exemption. Furthermore, the government's lawyers argue that allowing such transfers to go untaxed would undermine the structure of the GST system. They contend that the one-time premium paid for the assignment of a lease is a payment for the service of granting access to the land for a certain period. If monthly lease rentals are taxable under GST, They question why a one-time premium for the same underlying right to use land should be treated differently. This creates an inconsistency, they argue, where the form of payment, lump sum versus periodic, determines taxability, which goes against the principle of a uniform tax. Finally, the tax department highlights the potential for significant revenue loss if the Gujarat High Court's view is upheld. Industrial estates across the country are developed on land leased out by government bodies. The assignment of these leases between companies is a frequent and high-value transaction. If all such transactions are deemed non-taxable, it would result in a substantial reduction in GST collections. The department argues that the legislative intent was to tax all economic activities except for a few specific carve-outs, and the sale of land was meant to be a narrow exemption. The dispute over GST on leasehold rights is not confined to Gujarat. It has become a nationwide legal issue, with similar cases emerging in various states. The Supreme Court has taken a significant step. It ordered the clubbing of multiple petitions that raise the same legal question. The court will hear several related cases together, including the original challenge to the Gujarat High Court's decision. This consolidated hearing allows a comprehensive examination of all facets. Other high courts have taken a cautious approach. The Bombay High Court, for example, handled similar cases while mindful of the pending Supreme Court matter. In one notable case, Panacea Biotech Mankind Pharma, the Bombay High Court provided interim relief. The case involved assignment of leasehold rights from one farmer to another on land leased from the Maharashtra Industrial Development Corporation, MIDC. Faced with a GST demand, the court remitted the matter back to the GST authority for reconsideration, effectively putting the decision on hold. Lower courts prefer temporary relief or waiting for the Supreme Court to avoid conflicting judgments. This prevents legal chaos and ensures uniform application once the Supreme Court decides. The consolidation helps the court see how different state industrial development corporations structure leases and how businesses across sectors are affected. This comprehensive review is crucial to deliver a well-reasoned judgment that can be applied consistently across India's diverse economy. The Supreme Court's final decision will send powerful ripples far beyond the immediate parties involved. The judgment will have a profound impact on the real estate and construction sectors. If the court rules GST is not applicable on the transfer of leasehold rights, it could lead to a significant reduction in project costs for developers and builders. Many industrial projects are built on long-term leased land. Many commercial projects are built on long-term leased land. Removing an 18% GST liability on the acquisition of these lease rights would translate into substantial savings, potentially making projects more viable and attractive for investment. These potential cost savings could, in turn, benefit end users and buyers. Developers might pass on the savings in the form of lower prices for industrial plots, commercial spaces, or even residential apartments built on leased land. This could stimulate demand and encourage further development, particularly in urban areas where land is scarce and often available only on a leasehold basis. The decision could also impact the taxation of similar transactions, such as the transfer of development rights in real estate projects, which is another highly contentious area. A ruling in favor of the taxpayer could strengthen claims that these rights are also benefits arising from land and thus exempt from GST. On the other hand, if the Supreme Court sides with the tax authorities and declares that these transfers are taxable services, the industry will face a different reality. The cost of acquiring leasehold land for development will remain high, and this cost will likely be passed on to the final consumers. Developers who have not been collecting GST on such transactions might face significant tax demands for past periods, along with interest and penalties. This could create financial distress for some companies and lead to a new wave of litigation as they dispute the retrospective application of the tax. In conclusion, the Supreme Court's upcoming judgment is more than just a technical clarification of a tax law. It is a decision that will shape the financial landscape of India's real estate sector for years to come. The ruling will bring definitive clarity to a question that has created uncertainty and litigation across the country. By balancing the government's need for revenue, the principles of property law, the economic realities of the construction industry, the court will set a critical precedent. Whatever the outcome, the decision will resolve numerous ongoing disputes and provide a clear path forward for businesses and tax officials alike. Supreme Court, to examine if transfer of leasehold rights attracts GST.